The CEO's son fired me to hire his girlfriend. After I spent 3 years building the firm's client base and working 70-hour weeks. So I planned my revenge. In 30 days, the panic started. In 8 months, the firm was gone. Hey Reddit, so I spent 3 years of grinding 70-hour weeks at a Houston law firm. Never called in sick once. Then the morning I was supposed to close the biggest deal of my career, I got canned by some trust fund kid who'd never even passed the bar. His brilliant move? Firing me to hand my job to his girlfriend, who thought legal research meant asking ChatGPT for answers. I, 36 male, and I'd basically sold my soul to Sterling Legal, one of Houston's old money law firms. That Monday started the same way every other Monday had for 3 years. Coffee at 6:30, at my desk by 7, running through the Titan Industries acquisition documents for probably the 20th time. 800 grand in billings. Not our biggest deal, but solid enough that I'd personally babysat it through 3 months of back and forth negotiations while everyone else took credit at partner meeting. The email pinged at 9:47. Not from my direct boss who was stuck in depositions all week. This one came from Bo himself. Please come to my office immediately. Bo was 29, Stanford dropout who'd eventually scraped through law school somewhere else, though the firm's official bio said he'd pursued entrepreneurial opportunities before joining the family business. Son of the guy whose name had been on the building since 1986. The firm had brought him on 7 weeks back as executive director after what they called an extensive national search. The guy had failed the bar twice, stopped trying after his daddy made the whole thing go away by creating a position that didn't require a license. I saved my work and headed down the hallway. Bo had taken over the corner office that used to belong to one of our senior partners, a guy with 30 years of trial experience who'd won cases that made the legal textbooks. He got relocated to a windowless room near the break room 3 days after Bo arrived. Nobody talked about it. We all just watched a guy who'd argued before the Texas Supreme Court clear out his diplomas while Bo's interior decorator measured for new curtains. The law books and framed degrees were gone now, replaced by a neon sign that said, "Move fast and break things." Because nothing says serious legal practice like Silicon Valley cosplay. He didn't even look up when I walked in. Just sat there scrolling his phone, designer sneakers kicked up on his father's imported Italian desk. "It's Michael," I said, before he could call me the wrong name again. "We've met 6 times. I closed the Hansen deal last month. You signed the congratulations card." His eye twitched. Little tell that said I'd already gotten under his skin. "Good. Whatever. Look, I'm not going to waste time." He slid a packet across the desk. No build-up, no explanation. Just a stack of papers with yellow signature tabs like I was closing on a used Honda. "Today's your last day. You're firing me, the week before Titan closes. Madison will handle the transition." Madison, his girlfriend. The paralegal who'd started 5 weeks ago and still couldn't format a basic memo without calling IT 3 times. She'd worked at a nail salon before this. Nothing wrong with nail salons, but there's a learning curve when you jump from acrylics to acquisition agreements. I'd caught her using ChatGPT to draft a client update last week, complete with 3 hallucinated case citations that didn't exist and one that was from an entirely different state's jurisdiction. Madison doesn't have a law license. She legally can't. That's no longer your concern. His smile was all teeth, zero warmth, rich kid smile. The kind you pick up when you've never faced a consequence in your life. When every mistake gets cleaned up by daddy's money and every failure gets rebranded as a learning experience. You have 1 hour to clear out. And Michael, that NDA is non-negotiable. You discuss any client matters, any proprietary information, and we'll bury you in litigation. My father's firm has very deep pockets. 3 years. 3 years of skipped vacations, working through food poisoning, building relationships with 41 corporate clients who called my personal cell at 2 in the morning when deals fell apart. 3 years of holding this place together while the partners took long lunches and Bo's father collected checks from a beach house in Galveston. And this trust fund accident was handing it all to his girlfriend because she looked good in a pencil skirt. What's the actual reason? Not the synergy bullshit. The real reason. He leaned back, pressing his fingertips together, like a villain in a children's movie. Some TED Talk pose he probably practiced in the mirror. "You're a dinosaur, Michael. Old school. The firm is evolving and you don't fit the culture I'm building. We need fresh perspectives. Innovative thinking. Innovative people who understand disruption. The culture where your girlfriend replaces a licensed attorney? Watch yourself." His voice went cold. First time I'd seen anything real from him. Underneath all that startup bro energy was something smaller and meaner. I could make this severance package disappear with one phone call. My father built this firm. I can rebuild it however I want. And frankly, You're lucky I'm giving you anything at all. I picked up the packet, flipped through it. Enhanced severance in exchange for a broader release and tighter non-compete than what I'd signed on day one. The standard employment agreement I'd inked 3 years ago already had confidentiality obligations and a basic non-solicit. Every big firm makes you sign one. This new packet was Bo trying to tighten the screws, adding restrictions that went way beyond the original. 3 months severance for signing away my right to talk, compete, or exist in any way that might embarrass the firm's name. But Texas courts had been gutting these overreaching non-competes for years. Getting fired so the boss's son could give your job to his unqualified girlfriend? That might qualify as the textbook definition of bad faith termination. Some judge was going to have a field day with this. 1 hour, Bo repeated, reaching for his phone. I slid the packet back, not signing anything new. Have counsel send it to mine. I walked out, still bound by my original agreement, the confidentiality and non-solicit from day one. But I wasn't giving him anything extra. Security showed up in under 3 minutes. 2 dudes I'd never seen before, which felt intentional. No small talk, no apology energy. They stood back while I packed, but it wasn't a suggestion. Behind the glass, the whole floor suddenly became obsessed with urgent emails. One junior I'd mentored looked up once, mouthed, "Sorry," and immediately went back to typing. Word was already out. I was toxic. They gave me an hour to pack up 3 years. I grabbed the stuff that actually mattered, my personal laptop, the one that kept the place running when their servers face planted, my phone with client numbers and my own contacts, not their trash CRM, my contract law books full of my notes, and the photo of my dog that had been on my desk since day one. What they couldn't box up was everything that actually mattered. The relationships, the trust, the 2 in the morning phone calls where I talked executives off ledges when their world was falling apart around them. 3 years of knowing which client needed reassurance and which needed a kick in the ass. 3 years of remembering birthdays and anniversaries and kids' names. None of that fit in a banker's box. I walked out past the commissioned portraits of 3 generations of firm founders staring down at me. Arthur, the founder, who'd represented Houston's oil barons when Texas was still wild. Douglas, the builder, who'd turned a 3-person shop into a regional powerhouse. And somewhere in the back office, posting Instagram stories about the grind, Bo, the destroyer. But as I pushed through those glass doors for the last time, I wasn't thinking about what I'd lost. I was thinking about what they'd forgotten I still had. Sitting in my home office at 2:15 in the afternoon, still in my suit, staring at that pathetic banker's box like it might suddenly explain what the hell just happened. The house was too quiet for a Monday. My dog Murphy kept looking at me from his bed, head tilted, confused about why I was home. I should have been in the Titan meeting right then, walking Lydia through final terms, celebrating another deal closed. Instead, I was unemployed, and my dog thought I'd lost my mind. The shock was wearing off, though, getting replaced by something sharper. Not anger exactly, more like that cold focus you get when someone finally shows you who they really are. You spend years telling yourself that loyalty means something, that hard work gets rewarded, that the system is basically fair if you play by the rules. Then some trust fund kid fires you to give your job to his girlfriend, and you realize, oh, that's how it works. Good to know. I made a pot of coffee at 2:30 in the afternoon because sleep was optional now, and started figuring out what I actually owned versus what the firm thought they controlled. Turns out, a lot. Templates I'd built on my own time, on my own laptop. 41 executives who texted me photos of their kids' graduations and called my personal cell at 2 in the morning because the firm's official channels were useless. And 3 years of knowledge that couldn't be handed off, like the hidden arbitration clause I'd found in Titan's vendor agreements that could have cost them millions, quietly fixed across 17 contracts before anyone even knew there was a problem. My phone buzzed. Text from a junior associate I'd been mentoring, the one who'd avoided eye contact on my way out. Heard what happened? Can't believe it. Bo says Madison is taking over your files. She's supposed to be the client-facing point person now, scheduling, correspondence, routing drafts to the junior associates. Except she just asked the paralegal pool what consideration means in contract law. Like, the basic concept. The associates are scrambling behind the scenes, but nobody's actually supervising them. We're so screwed. I didn't respond. My original employment agreement was vague about personal communications, and I wasn't taking chances yet. But the text confirmed what I'd suspected. Panic was already setting in over there. By 4:30, I'd turned my dining room into Command Central. 3 years of knowledge spread across the table. Not client files. Those belonged to the firm legally. But my personal notes, my systems, my frameworks, the infrastructure that had made me valuable in the first place. The stuff they didn't even know existed. I set up a new email, CM Consulting. Not a competing firm. That might violate the non-compete. Just a professional presence. Updated my LinkedIn to independent legal consultant. No mention of the old firm. No violation. Then I waited. First text came at 5:43. Lydia from Titan. Michael, the new lawyer just asked me what force majeure means. In the middle of our deal review. Please tell me this is some kind of joke. I stared at the message. Technically responding about the Titan deal would violate my confidentiality obligations. But expressing sympathy for a friend's frustration? That was just being a decent person. No longer with Sterling as of today. Hope everything goes smoothly with your deal. Her response was instant. What? Call me now. Bound by certain agreements. Can't discuss specifics. You should probably get independent counsel before making any decisions. Can you discuss anything? Over coffee? As friends? I smiled for the first time all day. As friends, always. By 8 that evening, I'd gotten similar messages from 4 other clients. Word spread fast in Houston corporate circles. Everyone knows everyone. Everyone talks. I didn't reach out to anyone. Didn't send a single blast email. Didn't work from any client list. Didn't solicit a damn thing. They found me. Each time, I kept it clean. Confirmed I was gone, noted I was restricted, suggested they get independent advice. Made it clear I existed. I was out here. And I wasn't the one who'd abandoned them. Then my mom called. I should have let it go to voicemail. I knew better. But 3 years of corporate law had dulled my survival instincts when it came to family drama. Michael, honey, I just got off the phone with Bo. My stomach dropped. You did what? Called the main line. Told them I was your mother and demanded to speak to whoever fired my son. Gave that little snot a piece of my mind. Told him his father should be ashamed. That I know people at the Chronicle. That what he did to you was probably illegal. Every single sentence was ammunition for a harassment claim. Evidence that I was orchestrating a campaign against the firm through third parties. Proof that I couldn't be trusted to honor my agreements. Do not contact them again. Ever. I'm just trying to help, sweetheart. You always did let people walk all over you. Mom, listen to me very carefully. You are not helping. You are handing them a weapon. Do not call the firm. Do not call the Chronicle. Do not post anything on Facebook. Do not talk to anyone about this. I will handle it. Are we clear? Silence. Are we clear? Fine. Her voice was small. Hurt. I didn't have time for hurt. I'll call you when this is over. I hung up. Then I sat down and drafted an email to the firm's outside counsel. No apology, no explanation, no emotion, just documentation. RE. Third-party communication. I did not authorize or direct any communication from any third party to your client or any representative of your client. I have instructed the individual in question not to initiate further contact. Please direct any additional correspondence regarding this matter to me directly or to my counsel. Sent. Then I saved a PDF and forwarded it to my counsel. The email documented 3 things. I didn't direct the contact, I stopped it, and I wasn't playing games. No groveling, no panic, just process. Bo thought he'd removed a replaceable part from his machine. What he didn't get was that modern legal practice isn't about marble lobbies and family names on letterhead. It's about the 3 in the morning phone calls, the weekend emergencies, the trusted voice who actually knew what force majeure meant and could explain it without checking Google first. They had the building. I had everything else. 4 days into unemployment, I sat across from Warren in a conference room that smelled like money and old leather. His firm was 8 blocks from my old shop, close enough to share lunch spots, far enough to maintain professional distance. I'd reached out through a mutual contact, a guy who'd worked at both firms and owed me a favor from a deal gone sideways 3 years back. Framed the meeting carefully. Not job hunting? That might violate my agreements. Just 2 legal professionals discussing the market over coffee. The fact that we'd moved from a coffee shop to Warren's office by the second hour was his idea. Warren was 68, had built his firm from scratch starting in a one-room office in Montrose. 22 lawyers compared to my former firm's 140. But they'd survived 35 years by being smart instead of big. By specializing in corporate work that required actual expertise instead of just big firm letterhead. The kind of firm that survived recessions and industry shifts while flashier operations collapsed under their own weight. Independent work, he said, studying me over reading glasses. With your client relationships. I maintain personal friendships with Houston executives. Those friendships persist regardless of my employment status. Bo called me yesterday. Warren poured water from a crystal pitcher. His hands were steady. Warned me about a former employee who might violate his non-compete. Suggested any firm helping you would face significant litigation. His words. Said his father's firm has never lost a lawsuit. My stomach tightened. I told him his father's firm has never faced a lawyer who knows where all the bodies are buried. Warren set down his glass. also told him to take his threats elsewhere, but I used more professional language. The sentiment was clear. First time in days, I felt something like hope. The arrangement we worked out took 3 hours to nail down. Independent consultant, not employee. That keeps the non-compete in a gray zone. I'd work my own matters, build my own practice. Warren provides infrastructure, malpractice coverage, and most importantly, legal protection if the old firm got nasty, which they would. They will get nasty, Warren said. Douglas doesn't lose gracefully. He's been the biggest fish in Houston legal for 30 years. His ego can't handle this. And from what I hear, his son is worse. All the arrogance with none of the accomplishments to back it up. I'm counting on it. My phone buzzed before I could explain. 3 texts in rapid succession. Lydia. Deal fell through. Madison missed critical deadline. Board is furious. A CFO I'd worked with for years. Need to talk. Urgent contract issue. Call me. And from a number I didn't recognize. Mr. Michael, I'm general counsel at Foster Industries. Lydia suggested I reach out regarding representation. Are you taking new clients? Foster Industries, $12 billion in annual revenue, 3,000 employees. Never a client of my old firm. They'd been with a Dallas firm for years. I looked up at Warren. I accept your terms. When do I start? How about right now? Looks like you've got some calls to make. The first real domino fell at 3:22 on a Tuesday morning, 2 weeks after I'd set up at Warren's firm. My phone lit up. The general counsel at a holdings group I'd worked with for years. Their current lawyers, my old firm, had just received a compliance notice from the state. Data privacy violations. Potential fine in the 6 figures. Their lawyers said it was nothing. Don't worry about it. She was worried about it. I found the issue in under 5 minutes. Outdated retention policies. Exactly the kind of thing I'd flagged in a firm-wide memo 8 months ago. A memo that had been marked reviewed, but never acted on. A memo Bo had probably used as a coaster for his overpriced espresso. Deadline for remediation was Thursday. 2 days to fix something that should have been caught months ago. The next morning, her company officially retained Warren's firm. Their first request? All documentation from my old firm regarding previous compliance work. The files they sent over were a disaster. 2019 templates in a 2024 regulatory environment. Zero evidence of the audit I'd recommended. Warren walked into my temporary office around 10, grinning like a kid on Christmas morning. Their paralegal just called. Wanted to know if we have a template thingy for data privacy compliance. Direct quote. Madison? The very same. Also asked if we could send over the checklist thing Michael used to use. Apparently she's heard you had systems. She's the point person for 41 corporate accounts by herself. 40 now. And from what I hear, she's routing everything to junior associates who are working around the clock with zero supervision. The partners are absent, the associates are drowning, and Madison's the only one talking to clients. The GC I just spoke with formally terminated the old firm's representation. Conflict of interest, she said. Can't have the firm that missed the violation defending against it. 1 down. 40 to go. But here's the thing about dominoes. They don't fall in nice straight lines. Not in real life. Real life is messier, full of setbacks and complications and moments where you think you've got momentum, and then everything grinds to a halt. The remediation took 72 hours of around-the-clock work. We filed the response with 8 hours to spare. Avoided a potential $600,000 fine. But then another client's urgent contract issue turned out to be a complete nightmare that required pulling in 2 additional specialists and 3 days of barely sleeping. One of my scheduled consultations fell through when the client got cold feet about switching firms mid-deal. Their CFO was golfing buddies with Douglas and didn't want to rock the boat. And my former mentee at the old firm texted me that they were telling clients I'd stolen proprietary information on my way out, that I'd copied confidential files, that I was dangerous and unstable. The whisper campaign had started. It got worse. One of my consultations, a promising lead from a medical device company, went completely sideways when their general counsel mentioned he'd heard concerning things about my departure. Wouldn't say what. Wouldn't say from whom. Just that vague corporate speak that means someone's been poisoning the well. I lost 3 potential clients that week, each one citing due diligence concerns or timing issues. Corporate bullshit for you're toxic. So I went robotic. Gym, office, sleep. Every rumor screenshotted. Every weird outreach logged. If they wanted a mess, they were getting paperwork. Warren pulled me aside after the 3rd rejection. They're playing dirty. Dirtier than I expected. I know. You ready for what comes next? He handed me a legal filing. Cease and desist letter, addressed to Warren's firm from my old firm's outside counsel, claiming tortious interference with business relationships, demanding I be terminated immediately or face litigation. The shot across the bow had arrived. 3 weeks in, and things weren't going according to plan. Sure, I had 7 clients who'd moved to Warren's firm. Real companies, real revenue, real proof that I wasn't crazy for thinking this could work. But the old firm was fighting back harder than I'd expected. Douglas had come out of semi-retirement, cutting short his Galveston Beach house exile to personally call every major client, reassuring them, promising them, lying to them about how stable the firm was, how the transition was going smoothly, how Madison was exceeding expectations. Bo was apparently on his best behavior for the first time in his life, attending meetings sober, keeping his mouth shut, letting Daddy clean up his mess while he nodded along like he understood what was happening. Then the malpractice carrier situation exploded. Warren called me into his office on a Thursday afternoon. He looked like he'd aged 5 years overnight. The old firm's carrier had gotten wind of the compliance mess. Worse, one of the departing client's general counsel had sent a formal reserving rights letter regarding potential claims. In insurance terms, that's a grenade with the pin pulled. The carrier launched an emergency review, started demanding documentation, asking uncomfortable questions about every file Madison had touched, jacked the old firm's premiums 40%, and demanded a formal remediation plan. How does this affect us? I asked. Our renewal is in 4 months. Carriers are going to start asking questions about everyone's supervision practices. Warren poured 2 glasses of water. Your revenge might blow back on the firm protecting you. The winning part looks clean on paper. The day-to-day was me eating cold takeout over my keyboard at midnight, spending half my time putting out rumors instead of doing legal work. Then it got worse. A bar investigator showed up 2 days later. Turns out a CEO whose family had been friends with Douglas for 40 years had filed a grievance against me personally, abandoning ongoing matters, leaving clients in the lurch, damaging client interests through negligent departure. Garbage complaint. I had documentation showing I'd been terminated, not that I'd abandoned anything. But complaints have to be investigated regardless. 2 hours of questions I couldn't fully answer without violating confidentiality obligations. The investigator was relentlessly, exhaustingly thorough, professionally neutral, never hostile, never friendly. Just pen on paper, steady and relentless, like watching your fate being written in real time. After she left, Warren closed the door. That complaint has the old firm's fingerprints all over it. The CEO's father and Douglas were in the same fraternity. This is coordinated. They're not just fighting to keep clients. They're fighting to destroy you personally. 3 weeks ago, I'd walked out thinking I had all the leverage. Now I was looking at bar investigation, insurance complications, and a whisper campaign designed to make me unemployable. Bo was an idiot, but his father wasn't. What do we do? Warren smiled. It wasn't a nice smile. We stopped playing defense. The bar complaint ended up being the best thing that could have happened to me. See, here's what Douglas didn't anticipate. When you file a grievance against someone, you create a paper trail. You open a door that swings both ways. And when that paper trail gets examined by investigators who actually know what they're looking for, it reveals a lot more than just the target's supposed misconduct. Our response to the bar included a detailed timeline of my termination, the lack of transition period, the replacement of a licensed attorney with an unlicensed paralegal as the client-facing point person, the fact that Madison had no legal training and was coordinating matters that required proper attorney supervision, routing work to unsupervised junior associates, communicating directly with clients on legal strategy, the missed deadlines that followed, the compliance failures, everything documented, everything time-stamped. The bar investigator started asking questions, not about me, about the old firm's supervision practices, about who was actually doing legal work over there and what their qualifications were. Suddenly, the complaint wasn't about me abandoning clients. It was about whether they had engaged in unauthorized practice of law by allowing Madison to coordinate matters without proper oversight, and whether the firm's supervision failures had created the very client harm they were blaming on me. The boomerang had started its arc. Meanwhile, I'd been quietly building something else. Remember those regulatory alerts I'd flagged back when I was at the old firm? The ones in the firm-wide memos nobody read? I'd kept copies of my own analysis, general commentary on regulatory changes affecting Texas businesses, public information that anyone could access if they knew where to look. Nothing confidential, nothing client-specific, just my professional observations on developments in the law. I started publishing a LinkedIn newsletter, regulatory updates for Texas businesses, public service content about compliance changes and common gaps. My name on every post. Completely transparent. Completely devastating if your current law firm hadn't been keeping up with changes I was explaining to anyone who'd read. The calls started coming faster after that. Our board has concerns about regulatory exposure. We need a second opinion on our compliance posture. Someone sent us information about data privacy requirements. We'd like to discuss our current representation. but some leads still went mysteriously cold. Same pattern, initial enthusiasm, then sudden radio silence, and vague emails about timing concerns. The Whisper campaign wasn't just coming from the old firm. Someone else was working the Houston Assistant Network, the EAs and HR coordinators who trade information at quarterly luncheons. One raised eyebrow from someone plugged into those circles can poison a dozen leads without leaving fingerprints. Corporate people are allergic to drama. They don't need proof. They need plausible deniability for passing on a candidate. I couldn't prove who was behind it, couldn't confront anyone without looking paranoid. But I could build a firewall. I called every client who'd moved to Warren's firm and asked them to vouch for me, not to strangers, but to their peers. CFOs to CFOs, general counsels to general counsels. Real references from people who'd actually worked with me, not lunch table rumors. If you can't name specifics, it's just gossip, and corporate people can smell that from a mile away. The client count climbed anyway, 12 by week 4, then 15, then 19. Still, for everyone that jumped, 2 stayed because Douglas played golf with their CFO, or because nobody wants to be first to leave. The wins were fuel. The ones who stayed felt like betrayal. Meanwhile, the old firm's malpractice carrier kept tightening the noose. The 40% premium hike was just the opener. Now they wanted a formal remediation plan, which meant outside consultants digging through their processes, which meant admitting their processes were broken. Clients saw auditors crawling around and started getting nervous. The bar complaint was still hanging over me, and I wasn't sleeping. Not grind-set sleep deprivation. More like my brain refusing to shut off. Then week 7 hit. A process server walked into Warren's office with a stack of lawsuits thick enough to double as furniture. They sued me personally, sued Warren's firm, and sued 3 clients who'd switched, claiming tortious interference. They'd hired a notorious plaintiff-side litigation shop, the kind of firm that defends tobacco companies and chemical polluters. When you hire lawyers like that, you're not looking for justice. You're looking to bury someone in legal fees until they surrender or go bankrupt. The morning the lawsuits were filed, Lydia called. "Michael, I just got served. They're claiming I conspired with you to destroy their firm. I'm being sued for hiring a better lawyer." "I'm sorry you got dragged into this." "Don't be. There's a Houston GC roundtable, informal group of general counsels who share notes on outside counsel. We're coordinating defense costs. Pool the risk, share the burden. They won't back down from a handful of defendants." "Good. Let them burn through their legal budget fighting a war on multiple fronts." Within a week, the defense coalition had grown to nearly 30 companies. It wasn't some dramatic alliance with a war room and matching jackets. It was a group chat, a shared retainer agreement, and a bunch of corporate people who loved paperwork more than they loved drama. Years of being overcharged by big firms, years of feeling like they existed to fund partner bonuses, all that quiet resentment had been sitting there waiting for a reason to move. Now they had one. They pooled resources and hired a litigation boutique that had built its entire reputation on one thing: making aggressive plaintiffs regret ever filing. The boutique's senior partner had a nickname in Houston legal circles: the Refund, because companies who sued his clients usually ended up paying for the privilege, and the old firm's lawyers had made a critical error. To prove I'd stolen client relationships, they needed to show those relationships belonged to the firm, which meant deposing every client who'd left. 37 witnesses ready to testify they'd trusted me specifically, not the firm's letterhead. They'd just handed us the ammunition to destroy their own case. 2 weeks later, while I was still fielding calls from nervous clients and running on 4 hours of sleep, the bar's initial inquiry into my conduct concluded. The bar investigators' report found insufficient evidence of misconduct on my part, but it found substantial evidence that the old firm had engaged in supervision failures and improper delegation. The report recommended further investigation into the firm's management structure and oversight procedure, triggering an expanded review that would dig far deeper than the original complaint ever intended. Bo's name came up in the initial findings, but not the way you see on TV. No public wanted poster, no formal sanctions plastered on the bar website, just preliminary observations about his role in the supervision breakdown. Observations that would be examined more thoroughly in the expanded investigation. Douglas had weaponized the bar against me. The bar had decided to investigate him instead. 8 months. That's how long it took for everything to fall apart completely. The bar's expanded investigation spread like a crack in a windshield. What started as an inquiry into my conduct had become a full audit of the old firm's practices over the past 2 years. Every file Madison had touched, every deadline that had been missed, every client who'd suffered because a 29-year-old Failson decided innovation meant replacing expertise with loyalty to whoever was sleeping with him. The final findings were brutal. 17 instances of improper delegation to unlicensed staff. 9 missed filing deadlines with material impact on client matters. 2 cases where clients had suffered actual financial harm due to negligence. One had paid a late fee that wouldn't have existed if someone competent had been watching the calendar. And one spectacular example where Madison had accidentally CC'd a client on an internal email discussing how to hide a mistake she'd made on their account. That client was now suing the old firm directly, separate from everything else. The firm's malpractice carrier finally pulled the plug, dropped them entirely, effective 60 days out. Finding new coverage with that kind of record? At any reasonable rate? Basically impossible. The insurance spiral had become a death spiral. Douglas announced his retirement. For real this time. The official statement mentioned spending more time with family and pursuing other interests. Everyone in Houston legal circles knew it meant he'd rather walk away from 40 years of building than watch his son finish destroying everything he'd created. Bo didn't take over. The remaining partners staged what amounted to a coup. They voted to dissolve the firm name entirely and merge with a Dallas firm. The merger was technically an acquisition. The remaining lawyers would become employees of the new firm. The Houston office would survive in some form, but the old name would disappear from the letterhead for the first time since 1986. The lawsuits against me and the defense coalition quietly settled. No admission of wrongdoing on either side. That was the face-saving language. But the settlement included a requirement that the old firm, now technically part of the Dallas firm, pay the coalition's legal fee. Every dollar they'd spent trying to destroy me through litigation, every hour the boutique had billed defending us, they had to reimburse. The coalition's litigation counsel sent a final bill to the old firm for $2.3 million, payment due in 90 days. And then there was Bo. The bar's investigation had focused mainly on the firm's practices as an institution, but there was a specific finding about him, that he had exercised supervisory authority over legal matters without proper licensure or oversight. Not quite practicing law without a license, but close enough that hiring committees would see it and run. The kind of finding that doesn't make headlines, but shows up in every background check, every due diligence review. Firms don't want the headache. They don't want to explain to their own insurance carriers why they hired someone whose name appears in bar investigation records next to phrases like supervision failures and improper delegation. I heard through the grapevine that he'd tried to get a job at the Dallas firm after the merger. They declined. Tried another firm in Dallas. Same result. Tried a small shop in Austin. They Googled him. When your name shows up anywhere near bar investigation records, even without formal public sanctions, it tends to end conversations quickly. Last I heard, he was running some kind of cryptocurrency consulting operation out of his apartment. Seemed about right. The final piece fell into place on a Tuesday in March, 8 months and 12 days after I'd walked out of the old firm with that banker's box. I'd just finished a meeting with Foster Industries. They'd become one of Warren's firm's biggest clients, and the relationship had expanded beyond anyone's expectation. Strategic planning, regulatory compliance, M&A advisory, the whole package. The kind of comprehensive representation I'd always wanted to build. Warren had made me equity partner 3 months earlier. My own division, my own team of 6. 31 of those original 41 corporate clients had followed me. The others had stayed with the merged firm or scattered to other shops, but 31 was more than enough to build something real. I was packing up my briefcase when my assistant knocked. Michael, there's someone here to see you. He doesn't have an appointment, but he says it's important. Who? Bo. I sat back down. Thought about it for exactly 3 seconds. Send him in. He looked like hell. Designer clothes gone, replaced by something off the rack that didn't quite fit. He'd put on weight, the soft, unhealthy kind that comes from too many late nights and too little reason to get out of bed. His eyes had that hollow look I'd seen in clients going through bankruptcy. Funny thing was, I didn't feel anything. No satisfaction, no sense of victory. Just a tired recognition that this was always how it was going to end. He stood in my doorway like he wasn't sure he was allowed to enter. Sit down, Bo. He did, in the low chair across from my desk. The same power play setup he'd used on me 8 months ago. He didn't seem to notice the irony. For a long moment, neither of us spoke. Traffic outside, the hum of the building's HVAC. Somewhere down the hall, someone laughed at something. I don't know why I came here. His voice was barely above a whisper. I just needed to see it. Where it all ended up. I waited. My dad won't talk to me. Madison left 2 months ago, took half the stuff from my apartment and blocked my number. He laughed, but there was nothing in it. Turns out she was sleeping with one of the lawyers from that litigation firm the whole time we were together. Found out at a dinner party. That was fun. I'm not your therapist, Bo. I know. He rubbed his face. I just keep thinking about that morning, when I fired you. I was so sure I was making the right call. You weren't, obviously. Another hollow laugh. You want to know the worst part? I actually believed it. All that disruption garbage. I actually thought I was going to change the legal industry, modernize my father's dinosaur firm. Instead, you killed it. Yeah! He met my eyes for the first time. Instead, I killed it. The silence stretched. What do you want me to say, Bo? That I forgive you? No, I don't expect that. He stood slowly, like his joints hurt. I guess I just wanted to understand how you did it. How you took everything apart so completely. I stood too. Walked around the desk until we were face to face. I didn't take anything apart. I just stopped holding it together. I handed him one of my business cards. Petty move, maybe. But I'm not above pettiness. You fired me because you thought the job was easy. Because you thought anyone could do what I did. Because you thought relationships were just names in a database that could be transferred like files. You found out the hard way that some things can't be handed off to your girlfriend. He stared at the card. Michael, equity partner. My name, my title, my new home, all the things he'd tried to take from me, printed on a little piece of cardstock. For what it's worth, he said quietly, I am sorry. Not that it matters now. It doesn't. He pocketed the card and walked out without another word. Didn't look back. Didn't shake my hand. Just shuffled toward the elevator like a man walking to his own funeral. I watched the doors close on whatever was left of the old firm's legacy. On 7 weeks of Daddy's failson and 5 weeks of girlfriend-based succession planning. On innovation and disruption and moving fast and breaking things. Then I went back to my desk and got to work. If you enjoyed this video, please hit that subscribe button. It really helps the channel and help us bring you more and better stories. Thanks.